All right, aspiring barristers, welcome. We're about to do a deep dive into a section of the Queensland Evidence Act that you absolutely have to master, Section 92. Think of this as your secret weapon for getting crucial documentary evidence admitted in civil proceedings. So let's start with the big question. Why does Section 92 even exist? Well, it all comes down to one simple, slightly scary fact. Human memory is fallible. It's just not reliable, especially under the immense pressure of a courtroom. And this commentary on the Act says it all. Memory isn't a perfect video recording, it's more like an impression. A document written down at the time of an event, well, that's almost always going to be gold by comparison. You see, the old common law hearsay rule created this really bizarre situation. It was so strict, it would often prefer a witness's hazy 2-year-old memory over a crystal clear document they wrote 5 minutes after the incident. It just didn't make a lot of sense. So Section 92 comes along and basically says, okay, let's be pragmatic here. It's the modern statutory fix for that exact problem. But remember, only in civil cases.
Okay, so here's our game plan for mastering this. We'll start with the core problem, then we'll dive into the solution that Section 92 provides. We're going to look at the 2 different ways you can get a document in, tackle the biggest hurdle, which is calling a witness, and then crucially, unlock the excuses that let you get around that hurdle. Finally, we'll tie it all together into a courtroom-ready argument.
So, let's just lock in the why. At its very heart, the Act accepts a simple truth. A quick note jotted down 5 minutes after an event is way more reliable than a memory that someone is trying to drag up years later in the witness box. This is the fundamental logic that drives everything else we're about to discuss. So now that the problem is crystal clear, let's get to the solution. Section 92 itself. You really should think of this as your gateway. It's a massive exception to the old hearsay rule, and it was built for one specific purpose: to get reliable documents into evidence. Now pay attention, because this is a big one. This is an exam trap just waiting for you. Section 92 is your tool for civil proceedings only. Seriously, do not try to use this in a criminal case. For that, you're looking at Section 93, and that's a whole different beast with its own set of rules. Okay, so Section 92 isn't just one single door. It's more like a corridor with 2 distinct doorways. And knowing which path to take, either 1A or 1B, is the absolute critical first step in making your argument.
All right, path 1. This is for your first-hand accounts. It's pretty straightforward, really. It's where the person who actually saw or knew the facts is the same person who made the statement. And, this is the key, they are available and you are calling them to testify. Think of a witness's own notes they scribbled down right after an incident. That's a classic example.
Now for path 2 under 1B. This one is way broader, and it is incredibly useful. This is your business records exception. Here, the info might have passed through a few hands before it got written down. The person who actually compiled the record, say the clerk who entered it into the system, doesn't need to have personal knowledge, as long as the information was supplied by someone who did. And this just shows how flexible and practical the Act is. The definition of who makes a statement, which you'll find in subsection 4, is incredibly wide. It's not just the person who is physically holding the pen. It could be your client dictating instructions to you as their solicitor. It could even be someone who was just aware that their statement was being recorded. It's very broad. Okay, so you've got your document, you've chosen your path, you're feeling pretty good. But hold on. This is where you're going to face your biggest challenge in court. You've got to clear a pretty significant hurdle. And here it is, the hurdle. You have a prima facie duty to call the original source of the information, the person who made the statement or supplied the info, so that they can be cross-examined. This all comes down to fairness, but let's be real, it's not always possible to do that.
So what happens when you can't call them? Well, this is where the true power of Section 92 kicks in. And frankly, this is where you earn your fees as an advocate, knowing how to get over that hurdle when calling the witness is just impossible. This is the key strategic question you have to be ready to answer. You can bet your opponent is going to object, so you need to have your response ready to go, and it has to be grounded in the specific provisions of the Act. And here is your toolkit. Subsection 2 gives you 6, count them, 6 statutory excuses or keys that unlock admissibility when you can't call the witness. You have to know these inside and out. Some are pretty obvious, like if the witness is dead or too sick to testify. But others are more nuanced and require some real argument, like proving they can't be found or that calling them would cause undue delay or expense.
Now remember, it's your job to prove one of these excuses to the court. And critically, Section 92, subsection 3 lets you use hearsay to do it. So a doctor's letter proving someone is unfit or a solicitor's affidavit detailing all the attempts to find someone, that's permissible. But a simple statement from the bar table, that is not going to be enough. And remember, the more important that document is to your case, the stronger your proof of the excuse needs to be.
Okay, so let's pull all these threads together. Let's create a practical framework that you can use to build your argument, whether you're in an exam hypothetical or you're actually on your feet in the Supreme Court. Use this simple 4-step checklist every single time. 1. Confirm you're in a civil proceeding. 2. Choose your path. Is it first-hand hearsay under 1A or a business record under 1B? 3. Assess the hurdle. Can you call the source? And finally, 4. If not, which of the 6 excuses in subsection 2 applies, and how are you going to prove it? Follow that structure, and your argument will be logical, structured, and complete. And here is the final, crucial takeaway for any good advocate. Getting the document admitted is only half the battle. Admissibility is not the same thing as weight. If your document gets in because you used one of the excuses, you can be absolutely certain your opponent will argue that the judge should give it very little weight because they didn't get a chance to cross-examine the source. You have to be prepared for that fight.
So as you prepare for the bar, don't just memorize the section, internalize the strategy. You've got to think like a barrister. You have the document, you now know the rules. The real question is, how will you build the compelling evidence-based argument that persuades a judge and wins the day for your client?